Okay, so, no, I don't want to say okay. Why are we having stage fright this time?
It's after lunch.
Today we're going to talk about the exclusive right to sell listing agreement. We've already done the buyer agency agreement, and now we want to point out the things that are really important in this listing agreement. It's much longer, so we won't be going into as much detail, will we, Chris?
I think that's safe to say, and we're going to look at it from a couple of different standpoints. This is completely for people in the pre-licensing class, so we will focus again on how you can relate it to other material that we studied and what you need to know for the exam. So Kandyce, would you like to kick it off for us?
Sure. Let's start with the title. This is the exclusive right to sell listing agreement. As you know, there are other types of listing agreements available here in North Carolina. This one, the exclusive right to sell, just as an overall review, is going to say, hey seller, we as the agent, as the firm, we're going to get paid no matter who finds a buyer. And we'll point out exactly where this contract says that, right?
That's exactly correct.
Right. This is the exclusive right to sell listing agreement. So again, in that first paragraph, we want to point out to people that this is between the seller and the listing firm. You are just an individual agent. So if something happens to you, not to be morbid, but you're hit by a bus, then that client is still going to be under contract with the firm.
Correct. One thing to mention on the sellers, and again, please relate it back to other information so that we don't have to spend a lot of time on it here. You have to name your sellers with certainty. If it is a married couple and they're both on the deed, they're going to have to be there. If you're dealing with an LLC or a corporation, you have to know who has the authority to sign on behalf of the firm.
Exactly. So next we have this note, and again, for class and test purposes, we're not going to go into a lot of detail, but it's talking about if you're getting ready to list a property by somebody who's either recently died or previously died, or anything going on like that, make sure you talk to an attorney and that you've got the right listing person in.
Exactly. Yeah. Some of what I just mentioned on the seller's part is reiterated in the blue. And then again, just as a test tip on this, take a look at all your contracts and remember, I know it sounds morbid, but what happens when someone dies? What happens when someone gets married? If it's a listing agreement, Kandyce had mentioned the idea that if it's one agent in the firm that dies, the firm would still maintain the listing. But if the seller dies, because this is a personal services agreement, if the seller dies, then the listing agreement becomes void. I'll give you a little bit of a foreshadowing on this when we get to the offer to purchase. If a buyer or seller dies, it does not terminate. So please go back and examine that in your notes.
All right. So let's go to our next section in the contract. I think this bold area, we saw it in the buyer agency agreement where it talks about the seller has received the working with real estate agents. And of course, that would have been at first substantial contact. And the term of agreement. Go ahead and tell us about that, Chris.
Well, the term of this agreement, unless it says otherwise in here, is going to be on the effective date of the contract, which means it's signed when it's signed by the parties and all the terms are filled out. If you have parties sign an incomplete contract, an incomplete agency agreement, it will not create the binding effect that you're looking for. But that's the idea, is that the term of this agreement shall start on the day that it's signed by all the parties.
Now, there is an option just in case they are already under contract with another firm, but you're going to talk a lot about that when you get to post-licensing, right?
Yeah, that can be a little bit tricky. Could you do a listing presentation for someone who's listed with another agent? Well, technically you can, but only based on the seller soliciting you. And then obviously you could not start that agreement until they were no longer working with another agent. That sounds to me like a topic for post-license.
Yep. Okay, so this is the term of the agreement, and we know that there's an important thing that has to be in all real estate agency agreements. Why don't you go ahead and give them that list again?
Yeah, same list we gave you on the buyer agency agreement. There are basically 5 things that have to be dealt with a agency agreement according to the Real Estate Commission. All agency agreements must be in writing. They must have a start date and an end date. They cannot be automatically renewable with the exception of property management agreements. They must have standard non-discrimination language, and they must have your license number. Remember how we looked at these in the buyer agency agreement? Note those as we go through this one as well. The first one that you'll see, of course, is on 1C. the expiration date. If you literally do not have the expiration date put into this contract, first of all, it's not valid. Secondly, it would be a violation of Real Estate Commission rule.
All right. The next section is section 2, the property. We know in order to have a valid contract, when we talk about the OTP, if we're going to be talking about deeds, we need to have a legal description. And this is where we're going to insert this legal description. There's a place for the street address, but you notice we also have a place for the plat reference here. You've got a PIN number, a PID number, you've got the plat book and slide. There's so much information here. We talk about the deed book. Do not freak out. Even though this is for the test, I like to remind you all that this is not a binding document that's going to be between the buyer and the seller. You're going to fill this out to the best of your ability, and then the attorney is going to help you once there's a buyer to make sure everything is exactly perfect.
Yeah, and in relation back to something we talked about a little bit earlier, of course, that would be the chapter of property descriptions. It gives you some of the options there. I believe more is better than less, but as Kandyce said, it's really important that that be correct by the time you get to the offer to purchase.
Perfect. So our next section is going to be on fixtures. We know that we talked about fixtures in class. This is the same language you're going to find in the offer to purchase and contract. It's a great time for you to talk to the seller about, hey, if you use the standard OTP, the form 2T, form 2T, then this is what a buyer's going to expect to be a fixture. By definition, a fixture is
an item that was once personal property. It's become real by virtue of the fact that it's attached to the house. And when you look at this list, let me remind you that when we're looking at these agency agreements, it is not your job to memorize them. It's your job to get a feel for the type of things that that arise in these contracts. That way you can sit down and have an intelligent conversation with the seller about the fact that, hey, unless you say otherwise, that ceiling fan is going to stay.
Let's point out some of the ones that we should probably be familiar with even on the test, like the stove, ranges, and ovens, and definitely the built-in appliances. I would say it's important for people to understand that landscaping and outdoor trees that are other than in movable containers, all of this right here, those are going to stay. And your mailboxes. Anything else you think they tend to focus on?
Well, at chapter 2, we spent a lot of time talking about what these fixtures are, and you kind of nailed them there. Light fixtures, which include chandeliers, obviously. Ceiling fans is another one that's easy to test on. And so what we're pointing out here is all of them are obviously important. Some of them come up more often than not. And that's the significance of some of the things that Kandyce has highlighted here.
Okay. So our first section are things that we're going to agree are fixtures. Anything that is leased or not owned by the seller is not going to stay. And if there's anything that the seller doesn't want to leave, they're going to put that in Section D, other items that do not convey. Remember, this is not the contract between the buyer and the seller. We are just having this initial conversation with the seller saying, let's talk about those things that you would like to see in the offer to purchase and contract as things you do not have to leave.
Yeah, in the field, you'll spend a significant amount of time on this with your seller, and there's probably some great advice to say, if you're not planning on leaving it, seller, let's take it down before the buyer ever sees it. But understand, what we're talking about now is the default of the way the agency agreement is, and then the language repeats itself in the offer to purchase and contract.
Exactly. Section 4 is our personal property. So often you'll have buyers that come in the house and they want that really nice washer and dryer. Well, that is not a fixture and it's not built in usually. So if that buyer wants it, that would be personal property. Right here in this listing agreement, this is a good place for you to discuss with your seller what personal property are they willing to leave. So it could be a washer dryer, it could be the refrigerator, what else? A lawnmower. And as long as you remember, it is at no value. So the buyer's not going to be paying the seller for these items. It's just included in the purchase price.
Yeah, we'll bring this up again in the offer to purchase. But this is just a conversation right now in regards to personal property. Just because they say they plan on leaving their refrigerator here, they may change their mind later. This is just the listing agreement. You can deal with that at a later time in negotiations.
Mm-hmm. Next, we have the home warranty. Have a discussion with your seller whether they're agreeing or not agreeing to get a home warranty for the buyer. It is not something they have to do. This is, again, a great time to have this conversation with your seller. Is it something that they are expecting or wanting to give?
Yeah, in the field, you should get great training from literally the home warranty companies on to how to handle these as well.
Mm-hmm.
Listing price in paragraph 6 is clearly going to be a material term of the contract. In other words, this contract would not even be complete and binding if you did not have the list price here. The other reason that it's important, in just a moment, we're going to talk about how an agent earns their compensation, with the emphasis being on earning the compensation. So let's say, for example purposes, that we're going to list this house at $250,000. The seller has asked us to procure a buyer at that term, $250,000. And then notice below that it actually talks about what payments they would accept. Would it be cash? Would it be conventional FHA or VA? Now that may sound like a silly question, but not all properties qualify for all types of finance, and so that would be significant as well.
Perfect.
We will revisit the list price after we talk about the next paragraph as well.
So our next section is the firm's compensation. One of my pet peeves is when people don't fill this out correctly. This is where the seller is going in and putting in the total commission. If you're putting this into the Triangle MLS, that listing agent, that seller, is promising to not only pay a commission to the listing agent, but a portion of that commission to a selling agent or a buyer's agent. This line right here is the total commission. Maybe it's 8% today. Sure, why not?
I like it.
So if it's 8%, we're going to go ahead and stick that right here. And I'm going to fast forward just to show people it is in Section 8 that you're going to split that. We'll get back to it later. But remember, in Section 7, we're putting the total commission. And here in Section 8, we're going to split that. And we're going to say whether we're willing to give some to a second seller's agent or a seller's sub-agent, and how much we're willing to give to a buyer's agent.
Perfect.
All right. Now let's go back up to Section 7. And Chris, tell us what you want to talk about.
I would like to mention one thing about the fee. Notice where Kandyce filled in the 8%, which is by far the most common way that agents are paid, a percentage of sale price. But note for test purposes, there are a couple of other ways that are tested on as well. One is what's known as a net fee. And in a net fee, basically an agent is being paid any amount of money above a certain agreed upon net. So for example, the seller said, well, look, if I get $250,000 in my pocket, you can have anything above that. Technically, that is a net fee, and that's not very common, but it doesn't mean we can't test you on it. The other one is a little more common, but you still don't see it quite as much as the percentage, and that's what's known as a flat fee. So basically, the way a flat fee would work is if I sell your house for $250,000, I get $5,000. If I sell it for $249,000, I still get $5,000. It's a flat fee, as the name indicates. Do not read into the fact that I've mentioned these, that they're complicated words. They just happen to be three methods of paying compensation.
All right. So we've got the section of the contract that talks about the fee being earned, which is talking about when do you get paid. So this is what makes this an exclusive right to sell agreement. You, the listing agent, gets paid whenever a ready, willing, or an able buyer is procured by the firm, by another firm, or the seller. I don't care if aliens come down. When a buyer's found, you have earned your commission.
Correct. During the term of this agreement, you remember we had to name our dates a little bit earlier. We had to name the price. We had to name the dates because we were setting the terms of this agreement. Now, for test purposes, keep in mind, you are often tested on when you have earned the compensation, not when you are paid.
You're usually paid at the closing, or not at the closing table, after it closes, which is after it records. Remember, meeting together at the table, that settlement. Closing is having that settlement meeting, and then the attorney records, and then we're going to get paid. But going on, we've got our protection period. We saw this as well in the buyer agency, didn't we?
Correct. It just simply protects you if, in fact, the agency agreement expires and then a buyer who you procured during the term of the listing agreement comes back and buys the property within X number of days. Very, very similar to what we talked about in the buyer agency agreement.
So that's the protection period, and it's also called
the extender clause.
The extender clause.
Sometimes referred to as the override clause.
Or the override clause. All right, I'm going to move forward a little bit. Again, since this is pre-licensing, we're not going to go into too much detail, but I am going to mention right here in Section E, if you are an agent in North Carolina and you are getting additional compensation, you must let your seller or buyer know.
I did want to say before we moved on, transfer of interest in a business entity. Don't go deep into this. I just moved up one to D. But again, the commission will test you on not only if you sell the property, but what if you sold a 1/3 interest in the property? Mm-hmm. Well, it's very possible that you would be entitled to 1/3 of the commission that you would receive. Not the whole commission because you didn't sell the whole thing, but the 1/3. So when they talk about transfer of interest in business entity, it's just a little bit of a technical issue there.
All right.
Let's move on.
So Section 8, cooperation with and compensation to other firms. We have definitely talked about this just a little bit. We jumped ahead. And you've got these 3 check boxes. This is where the seller's going to say, am I willing to pay a buyer's agent? Which, again, in the Triangle MLS, that had better say yes. You must give something to that buyer's agent. And it is completely up to you and that seller as to what you want to offer them.
Yeah, while technically you're not obligated to do that, if you put it in the MLS and say you're going to pay, then you're obligated to pay, and that is by far the most common method in our area.
Mm-hmm. And then the seller can choose, well, are they willing to pay a second seller's agent or a seller sub-agent? That is when the buyers, or I should say the person helping the buyer, couldn't get the buyer to sign an agency agreement, and now that agent is going to work for the seller as well. If that doesn't make sense to you, or you're like, I think I followed, please take a look at one of our agency videos.
Yeah, I think that's correct. We could get into a long conversation about sub-agency and vicarious liability, but I don't think this is the appropriate time.
Okay.
In regards to paragraph 9, firm's duties, remember this is the agency agreement and we're just simply saying what the agents will do. And basically what we are for the seller is we are marketing firms. So we explain here what we do and what we do not do. We can't sell a seller's house. We don't own the house, so therefore we can't sell it. So what we promise to do is make our best efforts in procuring a ready, willing, and able buyer to which the seller can determine whether they want to sell it under those terms.
Perfect. And then the second paragraph talks about what we talked about in that professional services disclosure and election form, this idea that the seller needs to understand we aren't inspectors, home inspectors, we aren't plumbers, we aren't electricians, attorneys, lawyers, structural engineers. If they want those services, then they need to go ahead and hire those people, and they need to pay for those services as well.
Yep, short and sweet.
Now, this bold language right here, this is our non-discrimination language. And once again, we've already gone over the 5 things that have to be in every agency contract. Chris, hit it one more time for us.
All 5 of them include the fact that it has to be in writing. There has to be a start date and an end date, which we've seen. It cannot be automatically renewable. Agency agreements can't be automatically renewable. Agency agreements must have standard non-discrimination language, which we're looking at now. And then later you will see where the agent actually puts their license number on the form.
Perfect. Now, Section 10 marketing is very long. And once you become licensed, you're going to do a lot of talking about, well, when does it have to be in a multiple listing service? When can I put a sign out? When can I not put a sign out? Am I going to be doing open houses? All of those questions are going to depend on the house that you sell. But I do want to say in this Section 10, you want to sit down with the seller and be in agreement. Are they expecting that open house? Are they going to allow you to put a lockbox on the door? And you'll see here, you get almost a page of questions. So things like coming soon, that's going to be about you and your MLS. One thing we should talk about, though, is the seller acknowledgement. That seller acknowledgement is something for your clients to understand. Even though they're agreeing to open houses and showings, we as agent cannot guarantee safety or that somebody's not going to come in and do something crazy like steal medicines or, kill them in the middle of the night. But have that conversation, and more importantly, for me to you, please, please, please be careful anytime you are with the public.
That whole last page that we talked about, a lot of it has more to do with MLS, Realtor Association, and the Code of Ethics than it does commission rules.
All right. The big red box, again, we're just giving you some information here about federal and state laws. As a seller, it is against federal and state laws to listen or to record somebody without their express permission. So please let your sellers know, turn off the audio on a nanny cam, the door ring bell, doorbell, whatever it's called, and only do video surveillance. Now, earnest money. Chris, I'm going to let you go ahead and take that.
On this, I'm really just going to say what the contract says. There are a couple of things that the contract says, and it talks about the disposition of earnest monies. So, for example, because we're in the listing agreement, if there's any earnest money given, it says that it would be held by the firm. Well, keep in mind, this is the listing agreement, so that's talking about the listing firm. However, in all reality today, a lot of firms do not have a trust account, so therefore they do not hold earnest money. And you'll see when we get to the offer to purchase that there is actually a spot where we describe if a third party wants to hold the earnest money. The other thing that's kind of interesting in the earnest money is if for some reason that the buyer walks away from the transaction, forfeits their earnest money, this paragraph literally entitles the listing firm to half of the forfeited earnest monies.
That's exactly right, as I highlighted it here. All right, moving on. We've got our seller representations. This is while a seller is going ahead and letting you know, do they have flood insurance? Is there synthetic stucco? Remember, for us as agents, whether there is synthetic stucco or there's ever been synthetic stucco, that is a material fact that we must share. The seller's coming in and talking and giving information about the Owners Association. They're going to let you know that they don't, whether or not they have a termite bond, or basically that's a fancy way of saying, do they pay an insect company to come out and check for termites?
Yeah, a lot of what we're going through there is just simply diligence, trying to discover material facts of which the seller may be aware. Flood, synthetic stucco, termite. Do you have a homeowners association? If so, who's the contact person and how much do you owe?
Exactly. We have a place for liens, if there's any liens. Do they think they're going through bankruptcy? Now, this FHA appraisal, it is important to have that seller note whether or not an FHA appraisal has been performed on their property within the last 4 months. We definitely aren't getting into FHA things right now, but it is an important point to point out. And we're just going to keep on going. You see there's a place for special assessments. And remember, our special assessments are considered to be a specific lien here in North Carolina. So we want to know, are there any assessments that we should be taking care of?
Candice, will you do me a favor right there? Will you go ahead and highlight the words proposed or confirmed special assessments? I would like you to make note right now that those are going to be very important. Special assessments, are they proposed, which means that they're under formal consideration, or are they in fact improved, which means that they're either billed or about to be billed? I promise you that language is going to be important as we go through this form and also through the offer to purchasing contract.
Perfect. So manufactured homes, most homes that we think of are detached homes and they've been built on a permanent foundation. But if you are listing a manufactured or a mobile home, we need to include that as the personal property and include the VIN number. So is it okay if I skip down to section 13?
I think so. In the field, you're going to spend a lot of time worrying about fuel tanks when appropriate, but for our purposes right now, it probably would be a little over the head of the discussion.
Okay. So section 13 is going to be our seller's duties. They need to make sure that they fill out the Residential Property Owners Association Disclosure Statement, which we often call the RPODs. They're going to make sure they fill out the Mineral Oil and Gas Rights Mandatory Disclosure Statement, which we call MOG. And then if the house was built prior to 1978, they're going to give a lead-based paint or lead-based paint hazard addendum. Anything else that I want to point out here?
One thing I'd like to say about that, notice in the previous paragraph we talked about seller representations. We're just simply talking about things that they know. Please understand that this paragraph is seller duties. They could be in breach of contract for not cooperating with their agent in providing this information.
Mm-hmm. Oh, and something else that's really important. That seller is promising to make the property available for showings and keep working existing utilities on so that people can do inspections.
Yeah, this is a great conversation to have either in class or with your clients. But literally, we as agents can't sell the property unless it's made available for showing, unless it's kept clean. And so therefore, we could be out exerting a lot of work and not able to sell the property if they do not follow along with their duties.
Mm-hmm. All right, I'm going to go down to section 14, home inspections, where the seller just needs to let us know either they are or they aren't going to provide a home warranty. And then our photographs and other materials is a conversation between you and the seller as to let you know if there's anything you can't use, and that if you do take pictures of their home, it is going to be put onto into the internet or in flyers, anything like that. Right. Now, Chris, is there anything you usually suggest people add to the additional terms and conditions?
Well, again, I really don't want to get into this discussion. If you're just absolutely curious what would come up here, I'll give you an example. Let's say that I'm signing this agency agreement with the Jones family, and the Jones family has already talked to Mr. Smith about buying this property. So maybe they want me to exclude Mr. Smith, and they say, well, Chris, we'll pay you on everybody, but Mr. Smith, we had already talked to them. You could put him there as an exception. You could have done it on page 1 as well, but that would be the type thing an additional term might come up. Some agents charge a fee for storing documents and things like that. There are some things that I see occasionally there. If a client breaks the contract, sometimes there's a remedy for that in this. Don't focus on this for test purposes unless you know something that I don't know on that canvas.
I do not.
It is important in the field, but for test purposes, I wouldn't spend a whole lot of time on it.
All right. So now we're down to dual agency. So if I were to give a overall 30-foot view of what we've said, we've created exclusive right to sell agency with a seller. We've said, okay, seller, we are going to be your exclusive agent. We're the only ones that can market your house. And you're promising to pay us once a ready, willing, and able buyer is found by ourselves, the listing firm, any other firm, the buyer, or anybody else during the terms of this agreement. Well, that's awesome unless our firm has a buyer that is also represented by us, and that buyer wants to buy the home. Now what we're into is dual agency. So this is the part of the contract where the seller is going to give us permission to either be a dual agent or if the seller wants us to stay as an exclusive agent. So when you go over this with a seller, make sure that they understand the difference between exclusive agency and dual agency. And then you're going to get to this section right here, where a seller is going to either have to authorize us to be a dual agent, or they're going to authorize us not to be, or they don't authorize would be the right way to say that, a dual agent. And they're either going to initial here, or they're going to initial here.
Notice that that was an or.
It is an or, not an and. If they check this second line, then that's the only line they should check. But if they do the first line, they have the option of possibly initialing that third line. The first line says, I'll allow the firm to be a dual agent. This third section says, let me think about it, and if it's possible, I would allow you all to be my designated agent. Again, if you have questions about agency, now's not the time to talk about them in this video. Please, please, please watch our videos on agency.
Yes, a couple of things to add about agency. One, the language in the seller agreement, the listing agreement, is exactly the same as in the buyer agency agreement, except the word has the word seller instead of buyer. And I can't remember what my other point was on dual agency.
Yeah, that's okay. You'll come back to
That's
it.
fine.
All right, let's move on through mediation. The seller's agreeing that if there's any problems, instead of suing us outright, they're going to let us go through some mediation. We've got our wire fraud warning, which, we keep saying in all of these contracts, wire fraud has been a problem, so you should definitely let your customers and your clients know that any wire information needs to come directly from the attorney. It would never come from us as agents or anybody else. And then on our last page, we acknowledge that this is the entire agreement. So if you want to make changes or you want to terminate this agreement, that all needs to be in writing. So you'll have your seller sign, and if there's going to be an entity seller, maybe an LLC is selling something, you're going to have them fill out this section. And you're also going to have yourself, your own information here with your individual license number as well as your firm license number. So that's our 11 pages, Chris. Anything you want to add?
Just finally on the last page there, again, let me repeat that all sellers who you had on page 1 should be on the final page as well. Otherwise, it's not complete.
Exactly. Now, when you watch this video, I'm sure you noticed we took a lot more time at the beginning. And that's because I think it's fair to say most of the questions you get on the exam are going to be from that first 2.5, 3 pages. You want to make sure you understand about termination dates and effective dates, and definitely make sure you understand how you're getting paid.
Perfect.
And when you've earned that commission, which is when there's a ready, willing, and able buyer found. This is the exclusive right to sell listing agreement, and in class we'll have a little bit of a talk about the other 2 types of agency, exclusive agency and open agency. If you have any questions, just drop us a line at the bottom. Bye.
Bye-bye.